Begin at a doorway rather than a courtroom. A young woman stands at the edge of a Roman household. Behind her are the people, the gods, the property, and the obligations of the family she came from. Before her may be another household, another set of ancestors, another set of accounts, another legal place. Beside her are objects Roman law understood very well: a dowry chest, a wax tablet, a seal, a witness, perhaps a father, perhaps a tutor, perhaps in later years a patron. Roman law did not begin by asking whether women were free in one broad, abstract sense. It began by asking where this particular woman stood. Was she still under father's power? Had marriage moved her into another legal family? Was she legally independent, yet still required to act with a tutor? Was she free-born or freed? Could she inherit? Could she make a will? Could she manage property in her own name? And if she could, whose consent still stood near the document? Those questions matter because woman was not one simple legal category in Rome. A daughter, a wife in an old-form marriage, a wife in a free marriage, a widow with property, a mother with a statutory privilege, and a freedwoman still bound to a patron all stood before the law in different ways. To understand the subject, the ordinary questions must come in careful order. What legal place did birth give her? What changed when she married? What was a tutor? How did dowry work? What could she inherit? And which later reforms should stay in their own date, rather than being pulled backward into the early republic? The first caution belongs at the beginning. The clearest legal picture does not survive evenly across Roman history. For women's legal position, the evidence is strongest in the last 2 centuries BC and the first 3 centuries AD. The earlier republican evidence is much thinner, and later imperial and Christian law changed the picture again. So when we use the categories preserved by Gaius, by the Digest, or by later legal writers, we are using a later legal order to explain older developments whose earliest stages are less fully lit. The categories are useful, and they must be handled honestly. They are not a perfect recording of what a 5th century BC Roman household would have said about itself. Within that caution, the first thing to see is the familia. In Roman law, the familia was not the modern nuclear family around a table. It was the basic household and property unit, reaching through legitimate children, descendants through sons, slaves, and in some forms of marriage, a wife. At its head stood the paterfamilias, the male head of the household. The Latin word is familia. The legal point is sharper than the modern word father. A paterfamilias was the person who held family power and property in his own right. A legitimate daughter entered that world from birth as a filia familias, a daughter under patria potestas, the father's legal power. That is why a woman's legal position did not begin with marriage. It began in the father's house, inside a system that tied property, succession, status, and family identity to the male line. When a father died, sons under his power could become heads of new households. Women too could become legally independent in important ways, above all if no living father or husband held power over them. But no woman became paterfamilias in the Roman legal sense, and legitimate children belonged to the father's familia, not the mother's. Roman law recognized motherhood. It did not allow mothers to found the legal family line. The older powers attached to paternal authority were severe enough to trouble later Romans themselves. The father's legal position included broad claims of household discipline, the refusal to rear a newborn child, and in earlier law, powers of sale or surrender. By the classical period, some of the harshest claims had become embarrassing survivals, and practice could be softer than the old law allowed. The difference matters. We should not turn every household into a daily exercise of the worst power the law imagined, nor should we make the law gentle by looking only at ordinary affection. The structure gave the father real authority, and a daughter's marriage, property, and road toward legal independence all had to pass through that authority, or through the legal consequences it left behind. The next question is what marriage changed. Roman law asked first whether the parties had Conubium, the legal capacity for a recognized Roman marriage. Free citizens could have it, slaves could not. A union between enslaved people could be a real family in lived human terms, with partners and children and attachments, and it was not a Roman marriage in civil law. The distinction mattered because lawful marriage determined the status of children, and whether paternal power and agnatic ties followed from the union. Agnatic ties were legal family ties traced through male household power, not blood relationships simply, but the lines through which Roman family law organized succession, guardianship, and belonging. Rank mattered as well. Under Augustus, senators and their descendants were barred from marrying freed people and certain dishonored categories, actors, prostitutes, and convicted adulterers among them. These rules were not about romance, they were about status. Marriage law helped preserve rank, legitimate descent, and the movement of property among households thought suitable for one another. A marriage could hold affection, and inscriptions and letters show that the affection was real. But the legal order treated marriage as a public matter of children, status, property, and the continuity of families. Consent mattered, and it mattered inside that larger world. The parties had to intend marriage, a bride had to be present, and could not be married by proxy while standing somewhere else. Yet if the parties were still under paternal power, the paterfamilias had to consent, and if a bride was sui iuris, legally independent because no other person's household power stood over her, a tutor might still be required for certain legal acts. Families arranged marriages with dowry, rank, alliance, reputation, and succession in view. Roman law recognized consent in a society where household authority still did much of the ordering. The older and more structural form of Roman marriage was marriage with manus. Manus means hand, and in this setting it means marital power. In a marriage with manus, the wife passed into the legal hand of her husband or into the authority of his paterfamilias if the husband still stood under his own father's power. The jurists described 3 roads into manus. Conferitio was an old religious ceremony joined to an emma wheat cake and elite priestly tradition. Coemptio was a formal symbolic purchase, performed through the language of sale. Usus rested on continued cohabitation, though a wife could avoid it by staying away for 3 nights in the year. The rituals differed, the legal direction was the same. A woman moved from one agnatic world into another. In that setting, she came to stand in her husband's family much as a daughter stood there. Property she had held did not remain an independent sphere around her. Her rights of intestate succession in her natal family fell away. Intestate succession means succession when a person dies without a valid will. Manus shows what Roman marriage could mean in its strongest legal form. It could transfer residence, religious place, property position, and legal belonging. It did not merely create a partnership between 2 people. It moved a woman from one family line into another. By the late Republic, Manus was in retreat, and the retreat changed married women's legal position in a serious way. The increasingly normal form was free marriage, marriage without manus. In a free marriage, the wife did not pass into her husband's legal hand. If her father still lived and she had not been released from his power, she remained under that father's potestas. If she was already sui iuris, she remained legally independent, though she might still need a tutor for certain acts. Property that had not been made into dowry could remain her own. The husband held no patria potestas over her. That is a major change, and it should not be understated. A wife in free marriage was not absorbed into her husband's legal identity. Roman marital property did not become one shared pool in the modern sense. Either the wife was in manus and her property passed into the husband's household, or she stood outside manus and ownership remained separate apart from the dowry. But free marriage was not equality. It removed one older form of absorption while leaving in place the claims of the natal family, tutelage, dowry law, the father's power over legitimate children, and the social pressure of rank and reputation. It gave room without making the ground neutral. That brings us to Tutela mulierum, the tutelage of adult women. A girl who became sui iuris did not step into the independent adulthood a modern listener might expect. She moved from the guardianship of a minor into the tutelage of an adult woman. The old purpose was tied to property and succession. Roman law wished to regulate property leaving the familia. Certain acts, above all acts that diminished property or touched inheritance, needed a tutor's authority. In the older arrangement, the tutor legitimus was normally the nearest agnate, the nearest male line relative with a legal interest. For a freedwoman, the figure with the strongest claim could be her patron, the former owner who had freed her and kept important rights. The question, then, was never only whether a woman was capable of action. It was also who would lose an interest if she acted freely with property. A tutor was not the same thing in every period or every status. For some freeborn women, the tutor's consent became easier to compel and more formal. For freedwomen, patronal tutelage could remain far more serious because the patron held a real interest in the freedwoman's estate and succession. The same word could describe very different experiences. Even within the juristic record, Tutela was already under pressure. Testamentary appointments could loosen the grip of the old agnatic tutor. By Gaius' time, most tutors, apart from those with a real material stake, could be compelled by the praetor to give consent. Claudius abolished agnatic tutelage for freeborn women, while patronal tutelage over freedwomen remained more substantial. Gaius' own comment is revealing. The stock explanation said that women needed tutelage because of weakness of judgment. Gaius treated that explanation as more specious than true. The official language went on repeating incapacity, while the legal practice often admitted that adult women managed their affairs themselves. That practical evidence matters, or the subject becomes nothing but legal labels. One small and vivid example survives from Oxyrhynchus in Egypt. 3 sisters, sharing estates with a brother, contracted with a potter to produce jars for workshop use. That is not an image of women sealed away from economic life. It is an image of women acting through the channels their status allowed. The ius liberorum widened those channels further. This was the privilege of children. A freeborn woman with 3 children, or a freedwoman with 4 if she was sui iuris, could be freed from the need for a tutor. A later petition shows a woman invoking that privilege so that she might conduct her own affairs without a guardian. None of this removes the hierarchy. It shows that Roman law made room for action and distributed the room unevenly by birth, freedom, family, fertility, wealth, and patronage. The same household order appears in the way Roman law could read injury to a woman. A husband could bring an action for assault upon his wife. If she remained in her father's power, her father could bring one too. The juristic reasoning often treated the wrong as an insult to the authority of father or husband, where the offender knew the woman's status. That does not mean the woman herself vanished. It means the law often reached her injury through the household relations around her. Even personal wrong could be translated into the language of status and family authority. Dowry turns that order into something material enough to weigh in the hands. A dowry might be land, money, goods, a promise, a declaration, or a transfer arranged around marriage. Its basic purpose was to help bear the burdens of marriage, the expenses and responsibilities of the household the marriage created. In strict law, the dowry became the property of the husband, or of his paterfamilias if he was still under power, even in a free marriage. This is easy to miss, because free marriage let a wife keep separate property outside the dowry. The distinction is essential. Roman law did not say that everything a wife had became her husband's. It asked which property had been constituted as dowry and which property remained outside it. Over time, the law of dowry changed the meaning of the husband's ownership. The earliest model could look like plain acquisition. Later law kept the dowry within the husband's legal sphere during the marriage and built stronger devices to secure its return when the marriage ended. Special promises could shape recovery. Remedies existed to press for return. The husband came to look less like a man receiving a permanent windfall and more like a steward, entitled to use the dowry for the marriage while bearing duties over its preservation. He could answer for fraud. He could answer for negligence. Roman law still spoke the language of household property rather than equal partnership, and it recognized that dowry usually represented another family's contribution and should not simply disappear into the husband's hands. Augustan reform tightened that protection. Italian dotal land could not simply be alienated without the wife's consent. Dotal land means land that formed part of the dowry. It could not be casually turned into security for another's debt in ways that made the wife or her family bear the loss. Rules about deductions, expenses, and recovery on divorce grew more defined. Yet even here the law thought through family relations. A father who had provided the dowry might stand differently from the wife herself. Children of the marriage might justify certain retentions. The law was not only asking what one woman owned. It was asking which household had advanced the property, which household had benefited from the marriage, and which household ought to recover value when the marriage ended. Inheritance and wills carry the same pattern of opening and restraint. Freeborn women could make wills, but the road was guarded. Tutor consent mattered. Earlier devices, often involving coemptio, could be used to break agnatic ties so that property might move in a different direction. That tells us the deeper concern. The issue was not only whether a woman might choose badly. The issue was whether property might leave the channels Roman family law had built. By the classical period, many freeborn women gained broad practical freedom in making wills, because tutor consent could often be compelled. Freedwomen remained in a tighter place, because the patron's interest in their estate and his consent could be real. On intestacy, the older grammar shows most plainly. Women could be sui heiress. They could stand among the heirs who came directly under the power of a paterfamilias and became independent at his death. A daughter could inherit in that position, and a wife in manus could stand as if a daughter in her husband's family. But no woman could have sui heiress of her own, because no woman headed a Roman familia. That single rule says a great deal. Women could stand inside the inheritance system, sometimes near its center. They could not reproduce the legal family line in their own right. If there was no will, the estate moved first to those under power who became independent at the death, then outward to the agnates. The male line remained the organizing principle, even where women inherited and held property. The Lex Voconia made that principle harder and clearer. Passed in 169 BC, it barred men of the highest census class from appointing women as heirs. The law should not be turned into a false totality. It was no complete ban on female inheritance, and it did not erase female wealth. Women could still receive property by other routes, and Roman practice found ways around legal limits. The sharper point is what the law reflects: anxiety about where large patrimonies circulated. Wealth in women's hands could appear, from the viewpoint of elite male competition, as wealth moving away from the circuits of office, patronage, display, and public, rank through which the ruling class reproduced itself. The Lex Voconia was a measure about property and status inside a patriarchal order. There were later changes, and they matter, but they should stay in their own date. The Senatus Consultum Tertullianum strengthened certain mothers' rights of succession in relation to their children, above all where the ius liberorum applied. The Senatus Consultum Officianum later strengthened children's claims in succession to their mother. These measures gave stronger legal weight to blood ties through the mother than the older agnatic system had given, but they were later imperial developments. They were not the baseline from which the republican household began. The most accurate way to understand women before Roman law is therefore not one verdict, free or unfree, powerful or powerless, included or excluded. It is a map of status. A daughter under patria potestas, a wife in manus, a wife in free marriage, a sui iuris woman under tutelage, a mother with the ius liberorum, and a freedwoman under patronal claims did not stand in the same legal place. Roman law could let women inherit, make wills, petition, contract, commission work, manage estates, and move property when status allowed it. The same law could stop or redirect those acts through paternal power, tutelage, dowry rules, agnatic succession, and patronal rights. It opened room and never on neutral ground. That is why the doorway remains the right image. Before Roman law asked what a woman could do, it asked where she stood. From that answer followed her marriage, her property, her inheritance, and the measure of her legal voice.